Hello and welcome to the latest edition of our litigation podcast. Today we are going to look at the BHS wrongful trading case. I'm Robin Henry. I'm the head of dispute resolution at Colley Bristow. I'm here with Gavin Kramer. Gavin, would you like to introduce yourself?
I'm a senior associate at Colley Bristow specialising in contentious insolvency.
Okay, so what we're going to look at today is the BHS judgment against three of its directors for wrongful trading and trading misfeasance. I mean, it's a huge judgment, 533 pages long, and there's far too much material here for one podcast, so we're going to split this into two. And the first part, we're going to deal with wrongful trading, and the second part, we deal with trading misfeasance. Let's look at the background to this case. British Home Stores, abbreviated to BHS, was for many decades a very well-known national home furnishings retailer, which by 2015 had been making significant losses for a couple of years. And in the end, in 2015, the owner of British Home Stores, which was effectively Sir Philip Green, decided to sell the company for £1 to a company called Retail Acquisitions Limited, which was formulated or supported by Dominic Chappell and his associates. Now, that was a slightly unusual transaction to say the least, since Dominic Chappell had no retail experience, and he was a former racing driver, a former bankrupt. So he was an unusual choice to take over the running of what had been a very large retail organisation. Anyway, the long and the short of it is that they did take over BHS, and that the company collapsed into administration within a year of its purchase, and they did so with, amongst other things, a huge deficit in its pension schemes. So two of the directors, Leonard Henningson and Dominic Chandler, were ordered to pay £6.5 million each to BHS's liquidators for wrongful trading. They were also ordered to pay a further £5 million for breaching their fiduciary duties as directors. But there is going to be a further hearing to consider whether they're liable to pay even more to creditors for a claim which is called trading misfeasance, and we'll come on to that in the second half of the podcast, which essentially is failing to put the company into administration in the interests of creditors. Now, this is a very significant case when it comes to wrongful trading because of two things. One is the scale of it. I mean, they lost or caused losses to BHS of around £140 million in the course of 12 months. And so it's a huge claim that the liquidators have. And the second thing is that over the 40 years that wrongful trading has been on the statute books, it's been notoriously difficult to obtain successful wins for liquidators. So this is a very significant victory for the liquidators. So let's have a look at wrongful trading and why it has been so difficult in the past to prove. So wrongful trading was introduced in 1986, and it was supposed to be an easier way of holding directors to account for causing losses to an insolvent company, specifically because there was no need, as had previously been the case, to prove dishonesty on the part of directors. And I certainly think it's had a deterrent effect because of all the advice that has then been given to directors over the years. I've certainly advised directors on many occasions as to their potential liability for wrongful trading. But in practice, it's been very difficult to obtain successful wrongful trading judgments. So let's look at the actual section. What Section 214 of the Insolvency Act says is, if in the course of an insolvent winding up or an insolvent administration of a company, it appears that a person who is or was a director of the company knew or ought to have concluded at some point before the commencement of the liquidation or administration that there was no reasonable prospect that the company would avoid going into insolvent liquidation or insolvent administration, then the liquidator or administrator can seek a declaration from the court that the director should make a contribution to the company's assets. Now, there's a lot in that definition, and it's quite complex as to what needs to be proved. So, first of all, we're looking from the position of the company already having gone into administration or liquidation, and we're looking backwards in time at the action of the directors, which may be months or even years before. And we're looking at a particular point in time in the past at which the directors knew or ought to have concluded that there was no reasonable prospect that the company would avoid insolvent liquidation or administration. So we're going to have to reconstruct what the financial position was of the company and what the directors knew or ought to have known at that time. And we're going to need to look at what they knew or ought to have known about whether there was a reasonable prospect in the future that the company would avoid liquidation or administration. So we're having to look back in time, and then we're going to, from the point of view of the directors, we're going to have to look forward in time from their view as to what was going to happen to the company. And the courts will try and avoid seeing things with the benefit of hindsight. So that we're all going to have to reconstruct what was happening at a particular point in time in the past. And not only that, but notice it says directors, what the directors knew or ought to have concluded. So this is both a subjective test and an objective test. And what the section also says is that what we're looking at is what was known by a director who had both general knowledge, skill, and experience that may be reasonably expected of a person carrying out the functions of that director in that company, and the general knowledge, skill, and experience which that director actually has. Now, what that means is they are looking at the higher of either the knowledge that a very experienced director might have, in which case you take his actual knowledge and experience, or if you're talking about, as is the case in this case, directors who did not have a great deal of experience or skill or knowledge, they are judged by a reasonable standard, or a standard of what a reasonable director would do. And this is the introduction of what a notional director might decide in those circumstances. So that's looking at it. And what are we looking at here? We're looking at whether or not the directors think there is a reasonable prospect of avoiding insolvent liquidation or administration. And the way it's been expressed in many cases is that whether or not the directors can see light at the end of the tunnel. So is it reasonable for them to think that the company will survive in the end? If they are optimistic, they can be optimistic, but there has to be some sort of rationale for them to be optimistic as to what's going to happen. But that's not the end of it. There's one more thing that the liquidators have to show, and that is that if they've decided that they've reached the point of no return, effectively, that there is no prospect of them avoiding liquidation or administration, then the directors are going to be liable unless they took every step with a view to minimizing the potential loss to the company's creditors, as they ought to have done. Again, you're looking at what an objective director would objectively think about. So there is then the issue as to how much, if they don't think the company is going to survive or avoid liquidation, how much losses have the directors then caused to the company? And if they have caused losses to the company, then they will be responsible for those losses. Now, I'm sorry for taking up so much time, not letting Gavin get a word in edgeways there, but that's kind of setting out the law, the legal position as to what the court was going to be looking at. So, Gavin, perhaps you could explain how that is applied in the BHS case. What was the court looking at?
Thank you, Robin. Well, in this case, therefore, what the liquidators had to show or persuade the judge was that at a certain date, and this is termed by the judge the knowledge date, the directors who were defending the proceedings had what's called the relevant knowledge, or what the judge called the knowledge condition. So the knowledge condition is the requirement under section 214 that the directors know or ought to have known that there's no reasonable prospect that the company can avoid going into insolvent liquidation or entering insolvent administration. So that's called the knowledge condition. So the first thing is the judge had to decide at what point the defendant directors knew or ought to have known that the knowledge condition was satisfied. And the second requirement is that the liquidators bringing the claim have to state the date by which the knowledge condition arose. And that presents some challenge. That's quite a challenging proposition for those bringing the wrongful trading claim, because if they get the date wrong and the judge decides that the knowledge condition only arose at some later point in time, then the claim will fail. In BHS, the liquidators pleaded no less than 6 dates in the alternative as representing dates on which the knowledge condition arose. So the question, or what the judge had to do, was to look at each of those dates. The first of them was the 17th of April 2015, then the 6th of May 2015, the 26th of June 2015, the 13th of July 2015, the 26th of August 2015, and the 8th of September 2015. So the dates weren't very far apart, but in the case of each date, the judge had to be satisfied that the knowledge condition had arisen on or by that date. And interestingly, in this case, he concluded that the knowledge condition, i.e. a liability for wrongful trading, had not arisen in relation to the first 5 dates selected by the joint liquidators in their claim, and only arose on the final date, the 8th of September 2015. So had they not pleaded that date in addition, then the wrongful trading claim would in fact have failed.
And interestingly, it was agreed, which is unusual in this case, they had actually agreed between the parties as to how much loss had been caused by the directors on each of those dates.
Yes.
Isn't that right? And
yes.
there was quite considerable difference between them.
Yes, both sides called experts, but the experts agreed or largely agreed on calculating the quantum of loss. And in determining the loss caused by wrongful trading, the term used is it's determined by reference to what's called the increase in the net deficiency of the company. The judge used the shorthand IND in the judgment. So what he was required to do was to look at the increase in the IND, the net deficiency of the company, by reason of the directors deciding to continue trading after the 8th of September 2015, which he found to be the knowledge date, the date on which they should have concluded that there was no reasonable prospect of avoiding insolvent liquidation or administration, and should therefore have either ceased trading or to have taken every conceivable step to minimise the potential loss to creditors. And of course he found, well, they didn't cease trading, and he found that they didn't take every step that they should have done to minimise the loss to creditors that was caused by the company continuing to operate after the knowledge date of 8th September 2015. So the starting point for calculating their liability for wrongful trading is the increase in the net deficiency from the 8th of September 2015 up to the date on which the companies entered administration.
So why did he find that the first 5 dates were not sufficient for the directors to be found liable for wrongful trading?
That's a very interesting question, Robin. The judgment, as you'll appreciate, is very fact-specific, and there's a huge amount of detail. The judge has carried out a very careful analysis of the facts, but in summary, he found that in relation to the first 4 of the 6 knowledge dates put forward by the liquidators in their claim, the company, while there was a deficiency in relation to the pension, it was not, in his view, cash flow insolvent, and only became cash flow insolvent on the last 2 of the knowledge dates. And the judge concluded that it was only on the very final knowledge date, the September date, that for various reasons, including the cash flow insolvency of the company, the deficiency in the pension, and the inability to raise further funding other than on terms which were not commercially acceptable or should not have been considered by the directors to be commercially acceptable, that the directors had reached the point at which they should have concluded that there was no reasonable prospect of the companies avoiding insolvent liquidation or administration.
The judge was very critical of what the directors were doing, but what was it that convinced him that on the last knowledge date they ought to have realised that the company would not avoid liquidation?
Well, in the judge's words, the directors had embarked on what he called a degenerative strategy, that they had, almost from the date of their appointment, engaged in selling off or seeking to sell off the company's key assets, the crown jewels as they were termed, including major property holdings, in the hope that this would be sufficient to keep the company going until a rescue plan had been put in place and fresh funding had been raised. And what the judge found was that by the last of the knowledge dates, the degenerative strategy, as he termed it, was stripping the company of assets which could be sold to raise funds to enable further trading, but at the same time there was no real prospect of new funding being arranged. And the kind of funding that the directors were looking at were completely uncommercial in their terms. As the judge says in the judgment, that the directors were considering borrowing 48 million, they were considering entering into loan agreements which would have cost the group £103 million to raise only 48 million of new money. And this was a form of funding that no director acting reasonably and in the best interests of the company, and by this point the creditors, could have seriously contemplated. And it was therefore for this reason, because of the selling off of the company's valuable assets, that he came to the view that at that date they should have recognised that insolvent liquidation or administration were inevitable, and therefore the knowledge condition had been satisfied.
Yes, and it was very clear in the judge's view that point had reached at that date. There's just one further point that I want to raise about the judgment as it relates to wrongful trading, and that is this issue about professional advice. And the directors had sought to rely on the fact that they had taken advice from accountants and solicitors as to the position of the company. And they said that was a sort of prima facie way of them avoiding liability. And I just wonder whether, in your view, that is something which the judge took a novel approach in saying, no, that was not the case. Because what the judge said was that even if professional advice had been sought, whether or not that was much help to the directors would depend on exactly what advice had been sought, what assumptions and caveats the professionals had given in respect to that advice, and whether the directors had actually considered the advice and indeed heeded or not heeded the advice.
That's a very interesting question, Robin. The counsel for one of the directors made reference to the case of Sharp and Blank, a relatively recent case from 2019, where the judge said that in general, a director who takes and acts upon expert advice has gone a long way towards performing his duties with reasonable care. But what was interesting in this judgment is that the judge focused on the fact that it's not enough just to have taken professional advice, but as you were pointing out a moment ago, one has to look at the scope of the engagement, the nature of the instructions, the extent to which the advice was given on the basis of full information. In other words, the assumptions made by those giving the advice. And one also has to look at the extent to which reliance was placed on that advice by the directors. What I thought was particularly interesting is that the judge said that it was not part of the professional advisor's role to say whether or not the directors should cease trading based on the advice that they had been given and their knowledge of the company's financial circumstances. In particular, he refers to the advice given by a partner at Olswang, whose advice the counsel for the defendant directors sought to rely on, and made what I think is quite an interesting point. He says that Mr. Turner, who was the relevant partner at Olswang, emphasised in a memo sent to the directors on the 25th of August 2015 that it was the duty of the directors themselves and not his responsibility as their legal advisor to decide whether or not there was a reasonable prospect of avoiding insolvent liquidation. So I think what is significant here is that the judge is saying that ultimately the buck stops with the directors. They have to decide whether the knowledge condition has been satisfied. They can't say, well, our professional advisors failed to alert us to the fact that there was no reasonable prospect of avoiding insolvent liquidation or administration. It's their responsibility to reach that determination at the correct point, obviously taking account of advice they receive, but they can't pass on or pass off the responsibility and say it's for the professional advisors to tell them the point at which they need to stop, consider the position of the company, and if the knowledge condition is satisfied, to then take steps to place it into voluntary liquidation or administration. And the judge goes on to say, I accept that in many cases the legal advice which directors receive may provide an evidential basis for dismissing a wrongful trading claim where those directors carefully consider and follow the legal advice which they have received. But, he says, in this case, he's satisfied that they did not do so. And he goes on, in my judgment, Mr. Turner, the partner at Olswang who was advising the directors, raised all the right questions in his memo dated 25th August 2015, but his advice was never tabled or discussed at a board meeting before the decision was taken to enter into the Grove Point facility. And that's one of these commercially onerous loans which the judge felt no reasonable director acting in accordance with his duties would ever have taken on and imposed upon the company.
So that's really interesting. I think it shows it's a very interesting and clear explanation of the way in which both legal and insolvency practitioner advice is going to be viewed in these wrongful trading cases. But I don't think it creates any new or novel situations in terms of what advice should be given to directors in these situations.
But what it does make clear is ultimately the decision is theirs.
The decision remains with the directors.
It's their duty to come to the conclusion at the correct time, on the basis of their abilities, skills as directors, or if those skills are less than those that one would expect of someone in that position, the skills of the notional director, as the judge refers to it in his judgment, to reach that decision themselves. They can't say, I wasn't responsible for reaching that decision. It should have been my advisors to tell me at which point I should come to that conclusion. That defence won't work.
No, exactly. Okay, I think we're going to leave it there as far as the wrongful trading claim in the judgment relates, and we will come back with a second part where we will look at specifically the trading misfeasance claim, which is a new successful claim which was made in this judgment, and is a very interesting one, and I think it needs some detailed explanation. So we'll come back and provide you with that. But if you have any questions about wrongful trading or any other issues which arise from the judgment, please feel free to contact either me, Robin Henry, or Gavin Kramer at Collier Bristow.